Very good morning, participants. We will be starting the program shortly. Request all the participants to mute yourself. We had some technical hitches. The resource person was not uh, was not able to connect with our system, And today we are live streaming the program as well as we are recording the program. So almost 70 percentage of the participants will be in the live stream, and the rest people will be with us in the webinar room. So by 8:45, the resource person for the session one will be joining with us. Please be patient. Very good morning, participants. Please stay tuned. Uh, the resource person is trying to join with us. We had some technical problems to, to connect with the resource person. So we'll take another 5 minutes for connectivity. Then we'll start the webinar process by within 5 minutes. Thank you. I request all the participants to stay muted. Please mute your audio device and request everyone not to present anything in between. Uh, Mrs. Shivani Veer, could you please click on the stop presenting button so that, or else your entire mobile will be displayed all the participants. Yeah. Thank you very much. I request all the participants to stay muted, and I believe that people are joining in between, and the resource person is still trying to join with us. We have two versions on today. We have nearly 650 participants registered for the program. So we are doing the live streaming for the people who have registered after the 250 count. Request you to stop presenting. Could you please click on the stop presenting button? Mr. William Verghese, request you to uh, please stop presenting. Thank you very much.
Like the old man, look at the magician. The baby lesson was some guy that had in my mind. He came personally recommended from the guy around the warlock conference up on the desktop.
Dear participant, we have not yet started the webinar. Uh, we are waiting for the resource person to join with us, and a lot of people are still joining.
Get ready.
Request everyone to to mute your audio device. Cecil Joshi, whatever you are saying, it's audible to everyone. So request everyone to mute the person to join with us, and a lot of people are still joining. Get ready.
Is it okay now?
Perfect.
Okay.
I have uh, ended my audio call, sir. Now it's visible through the web. I mean through the Google Meet facility. So
Okay.
could you please adjust your cam so that you will be perfectly visible for all the participants?
How does one do that?
Yeah, it's okay now. Now it's okay.
No, no,
It's because of you have to adjust yourself with the cam. That's perfect now.
because
Uh,
I see.
sir, I believe that you should not come close to the camera. And now
Yeah.
it's okay. It's almost okay.
Uh-huh.
Okay.
Almost okay.
Yeah. Dear participants, faculty, the first resource person for the day, Professor Dr. S. Ramarao has joined with us. Request all the participants to pin user named S. Ramarao so that you can see directly the video feed of Dr. S. Ramarao. Moving to my responsibility of introducing giving an orientation towards the International Seminar on Intellectual Property Right, the IPR. Today we will be having 4 sessions. The first session will be by Dr. S. Ramarao, who was the former director of the World Intellectual Property Organization, Wipro, uh, coordinating from the office in New York. At present, he is in New York itself. And we have our beloved Associate Professor of Government Law College, Dr. Gifty Oman, as a second resource person for the day. And she will be handling what is a patent, foundation, and fundamentals of patent law. And moving further on session 2, after the lunch, the post-lunch time, we will have introduction to trademark by Advocate S. Sai Sushant. Sai Sushant is an famous national level advocate from Hyderabad, Telangana. And at the end of the day, we will have copyright protection and overview by Dr. Binu Purnamodan Cholail, who serves as associate professor in the Government Law College, Ernakulam. So today we will be having 4 resource persons for the day. And moving further to introduce our beloved speaker, the session 1, talk 1, introductory overview of intellectual property, Dr. S. Ramarao. Dr. S. Ramarao was the director of the Wipo Coordination Office in the New York. He has been the Wipo's representative since 1998 at the United Nations quarters in New York. Dr. Rao worked with the Ministry of Foreign Affairs of India for nearly 25 years and became its chief legal advisor. He was also the legal advisor to the Permanent Mission of India to the United Nations in New York from 1995 to 1988. Earlier, he was a full-time professor at the Advanced Legal Studies Department of University of Madras from 1977 to 1982 and lectured at several universities in United States of America since 1990. He was also a visiting faculty and a member at the Indian Academy for Diplomacy and International Law, Indian Foreign Service Institute, executive member of Indian Society of International Law, member of the editorial board of Indian Journal of International Law and the Indian Yearbook of International Affairs. And he is also an active member of the International Law Association in India branch. He is enrolled as a member of the bar at the Delhi High Court and has several publications international level. Dr. Rao holds the degrees like LLB, LLM from Andhra University, Voltaire, MPhil and PhD from Jawaharlal Nehru University, Delhi. So on behalf of Albertian Center for Human Resource Development and Research of St. Albert's College Autonomous, I cordially welcome our first speaker for the day, Dr. S. Ram Rao, who served as the director of World International, World Intellectual Property Organizations Coordinator's Office in New York. Hearty welcome, sir. Over to you for the session.
Thank you very much. I hope I'm visible to all of you. Good morning to you all in Ernakulam and Kerala and everywhere else in India. Let me, at the outset, take this opportunity to thank Dr. Steini Anthony for inviting me to speak to you today. Let me also thank Dr. Gefti Woman, Associate Professor, Government Law College, Ernakulam, for her kind personal in the matter. May I also thank the other speakers today, Mr. Karan, Dr. Binu Purnamadan Tulian, the colleagues will focus on the specific pattern trademark. I just want to check with you before. Am I okay? Am I audible? Visible?
Yes, sir. You are audible and visible. I request all the participants to mute yourself because some of the participants are not muted. So the speaker have some. I mean, the voice of the speaker will be difficult for you. So PS and associates, could you please mute yourself? I'm muting you. I request all the participants to mute yourself, or else your audio feed will be a really disturbance for the presenter to continue. I request all the participants to be muted throughout the webinar process. At the end of each session, you will have 10 to 15 minutes for the interactive session. For that, you can use the chat box button. In case if you would like to feed in any of the points, it will be shared with the faculty, either from my side or the faculty, the resource person himself could see the questions also. Either way, we will ensure that the questions are being answered. Thank you very much for your wonderful cooperations, dear participants. Over to you, sir. I'm sorry for that.
Thank you very much. That's helpful. And I would request you personally to intervene if there's any technical difficulty in terms of my being visible or not being audible at any stage. So others can mute, but you can always make me mute if necessary, as it were. Okay. Now, the topic for me for this morning is introductory overview of intellectual property. Now, let's get into, at a later stage, what is intellectual property, but basically we proceed on the understanding that we all know what is intellectual property. Obviously, it deals with the subject matter of the specific speakers who are going to follow me, like the patents, trademarks, and copyrights. It's all intellectual property. And in fact, if that is the case, whatever we do, for instance, I know it's too early in India at this time, and also because there is COVID. Otherwise, if somebody went to eat in McDonald's, that or if you wear a Omega watch or Rolex watch, or if you wear Lord Lauren, or if you have any of you having all these computers and the cell phones, whatever that we do in terms of the hardware, the software, the program, what we wear, what lipstick the ladies use, or anything could be today intellectual property. The modern world has come to a stage where it will be hard to distinguish what is not intellectual property and what it is. Now, let's, with your permission, let me make a generic, very generic understanding of intellectual property to move forward, because the specialists are going to speak on each of these categories, such as the trademarks, copyrights, and patents, or the other way around. It is essentially They're the creations of mind, and have gained a property value in which the owners or the authors have the exclusive right to such property. It is intangible, unlike what we can see, feel, and touch. We know what's our property. We know our apartment. We know our house. We know our building. We know our computer. We know whatever that is. All the tangible, movable or immovable properties, kinds of property. That's all real property. That's all tangible. What's the other way around is intellectual property, which is intangible, untouchable in terms of intellectual aspect of it. These are the creations of mind. Whichever manner they reflect. They reflect in different ways and categories. So that is the way the modern life is. Like if we have seen 4 industrial revolutions, like starting with the steam engine, to the mechanical, to the software of the 50s, or today's artificial intelligence, the 4th industrial revolution. In terms of the industrial revolution, in terms of the mechanized world, most of it has become intellectual property, one way or the other, as the creations of mind. It might have been there forever, don't know, but for sure, the milestones of legal recognition and legal endowment of these rights. Every right has a duty, right? But that's what the law is about. We all know in democracies, wherever we are. So this milestone development of intellectual property and property rights, say, commenced in a way along with the revolutions in terms of Renaissance period, or in terms of copyright in the Romanticism of the French or the Europeans. But the world also had faced and gone through colonialism. Like without steam engine, there would have been no colonialism, no Dutch, British, French, Spanish coming through almost through Cochin ports and going to Southeast Asia further and Asia further. So colonialism, Renaissance period, all of them had been the fertile grounds in a way, eventually, and the industrial revolutions eventually for intellectual property. There's something that happened. In 1873, in Austria, Vienna, they called for an international exhibit of inventions. International then meant essentially Europe, not even North America. But then Germany, which had the most patents and the engineers with all their cars and patents and the engines, blah, 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 or the Swiss with the watches, or the French with the copyrights, nobody turned up. Why? Why nobody turned out for the first European Invention Conference? For the fear that this is a trap. This is a trap to steal their intellectual property. This was, they thought, the Austro-Hungarian trap, to steal away the inventions of the Germany or sort of the great romantic copyrights of the French. So this was 1873. Then the Europeans met together and put their heads together, and then yep.
Dear participants, please mute yourself, or else it will be difficult for the resource person to continue the session. Request all the participants to mute yourself.
Okay.
Ravindra, please mute. Please, continue.
Yes. So therefore, to overcome that fear of stealing away of their intellectual property, the European powers came together, the civil law systems as well as the common law system nations, and agreed upon the first intellectual property international agreement, which is the Paris Convention on Industrial Property of 1883. Now, friends, industrial property here referred to the patents, trademarks, designs, mainly, industrial designs, mainly. But then copyrights were left out. As I already mentioned to you, that the Germans and the Swiss were more interested in the patents and the engineering and the technology side in terms of the inventions and the process of innovation, while the French started off with their great cultural things about art, culture, writing, authorship, etc. So the French interests were not covered in the Paris Treaty, though the treaty itself was entered into in Paris, in France. This led to further negotiations, having agreed to separate copyright as a different portal from that of the patents, trademarks, and industrial designs. Now agreed 3 years later in 1886 on the Berne Convention on Copyrights and Neighboring Rights. Okay. Now we have, by 1883 and 1886, we have the then existing intellectual property legalized or kind of codified into an international convention, in addition to the law and practices each of the European country had at that time. Let me also say here that India was already, was already in the British colonial map as the lodestar, as it were. So along with the UK making its own legislation, British legislation, the Great British legislation, also kind of reflected in a couple of years later in India. So India also would have, in the 1870s, a kind of patent legislation, and then later copyright legislation in India. Now, both each of them, Paris and Berne, have an administrative setup called Union. Paris has the Paris Union, Berne Convention has the Copyright Union. Union is essentially the administrative mechanism to administer those countries, these legal norms and standards that were stipulated in those international law, as it were, international conventions. This led to, in 1893, establishing a combined union or combined organization to administer these two unions, the unions that reflect and that maintain and implement these two conventions, covering the areas of patents, trademarks, copyright, industrial designs, and copyrights and neighboring rights as a whole, that had become the first international institution in the field of intellectual property ever, that is called a Unified Convention on International Intellectual Property, but it is called in the French acronym BIRPI, BIRPI. BIRPI was established in 1893 with its headquarters in Bern, Switzerland. Bern is the capital, though when we speak of Switzerland, we all think of Geneva mostly, including those who produce Hindi movies in Switzerland landscape. So now we have the first international organization for intellectual property, and with its headquarters in Burping. And then we have later that survived the First World War, that survived, now we are faced with the Second World War and the total metamorphosis of international life and organizations. This also coincides with, and one for us in India, to know that the Indian freedom struggle had also kind of geared up, moved forward. Then I don't want to get into the politics of the Second World War, but the consequence of the Second World War is, in terms of institutional relevance to us as a global partner and to intellectual property as the specific subject as well, is that the victorious powers wanted to establish an institutional mechanism that would stop any such war coming up ever. And there were three dimensions to it. One is the peace and security, to stop the war as such. Number two, to build the economic and developmental front post-war. Number three is to facilitate trade, international trade and trade mechanisms. On the first count, by 1945, we had the San Francisco Charter and we have the United Nations established, what we call as the UNO, the United Nations Organization. They agreed to be established. I don't want to take you to the dynamics of it, but that is an institutional, that is of institutional relevance. The concept there is that in terms of the post-war institutional establishment, there was no monolith concept that was agreed upon. That was a divided model. On one hand, for peace, war, security, human rights, etc., is United Nations. On the second leg, for the trade, for development and finances and the global exchange, currencies, etc., is the Bretton Woods organizations called the World Bank and IMF and International Finance Organization, IFC, now located in Washington. The first one located in New York. And the third is to establish a trade, a mechanism. Now, that trade thing failed. It could not establish a full-scale trade organization like the political United Nations or the economic developmental World Bank system. Instead, they agreed on one specific aspect to deal with tariffs of trade, which means tariffs means the prices, the commodity prices, so that one does not undermine the trade of the other by underselling the trade, by underselling the commodity, So they established standards of tariffs for the trade in respect of commodities. That became a small organization called GATT, G-A-T-T. My friends, one single point here, for all of you having known this, is that intellectual property is as such not included, was as such not included at that point in time. Either it was in the United Nations or it was in the World Bank system or even in the GATT. So intellectual property stood alone as it existed before the Second World War. So you had a burpee with headquarters in Bern, Switzerland, managing and administering the union that implements the Paris, and the Bern is in the copyright with reference to the Copyright Bern Convention. That was the state of law. That is the state of fact in terms of how intellectual property evolved. But interestingly, it was the United Nations Declaration on Human Rights following the Charter that had recognized in Article 27 thereof of the rights of the authors in their literary, artistic, and scientific works. So the first intellectual property right, or the endowment of the intellectual property rights and its recognition and establishment, lied in the heart and field, in the field of the human rights of the United Nations, UDHR, Article 27. Now, let me move forward because my time is different here, so I have just no clue. Somebody, I think, I would request the organizer to kindly warn me about the time. Now let me quickly run about to the intellectual property. So as we have already noted, I'll do it very quickly because of two reasons. Because of one reason mainly. Because the specific speakers following me who know the subject more will speak on patents, trademarks, and copyrights, each in the respective field, and they will delve deep into them. But however, it's my purpose now is to give an introductory overview of intellectual property rights, intellectual property. I cannot but proceed, I cannot but mention about intellectual property in terms of its purport, in terms of its connotation. Without that, I can proceed. Now, first, we have noted it is creations of mind, right? This is not physical property. It's intangible assets we are dealing with, and that you can't touch. And these are, in terms of categories, we have seen these are patents, copyrights, industrial designs, trademarks, and industrial designs at that point in time. They also now move further to include trade secrets, anti-competitiveness, geographical indications, and more to go, and more of direct relevance to Kerala and to India, which I will come towards the end. Now, how do you, two things, if each one is different, the category is different, though in a generic sense, they are creations of mind. Quickly speaking, just to touch without going deeper into any of them, because my following speakers will speak on that, would be that the individual who has invented and patented a particular patent subject matter has been given a legal entitlement rights to that product. These rights are exclusive. These rights cover use, manufacture, sale, transfer, or any of the dimensions of an absolute legal right. And they are given for a certain period of time. After that time duration lapses, after that time, if it is a patent or copyright, or they fall into the public domain, meaning thereby, like say, just one example, if we have a vaccine patented, hypothetically, if we have a vaccine patented today for COVID-19, its duration is for 20 years. After 20 years, it passes to the public domain, which means it falls into the public hands and public can do whatever they want. There's a whole dynamics of the pharmaceutical industry, of the manufacturing pharma and the generic industry, and India has mostly generic industry. I'm not getting into it, but I'm just flagging it. Well, what we are seeing conceptually here is there is an inherent individual right for the inventor or the author on one hand, and that right is endowed or limited or given or assigned for a certain period in time, and after the passing of that time, it goes into the public hand. Here, what we are seeing is a typical contractual setting in the society. It's like the Rousseau's contract of a contract. It's a contract between the society and the individual. And that is the same public interest and the individual interest that are sought to be matched up in the field of intellectual property. Now, essentially, when we're speaking quickly of patents, we are speaking of something of an invention, which is novel, which is new. Nothing is falling from the sky in terms of that newness. There's no new really. But the point is that it is new compared to what was in the past. So based on the prior art, you make an inventive step, you create novelty, that is new, and that is useful for the public. There is a utilitarian concept there, and there is a public interest involved there. All these elements constitute, for instance, a patent. Same thing with reference to trademarks. Different signs, emblems, marks, lines, whatever. If it is designs, it could be three-dimensional, it could be lines, whatever. And so in all these things, the philosophy remains the same in intellectual property. Now, when we speak of copyrights, typically all through this intellectual property, there are two schools of thought, which are very popular among the lawyers in jurisprudence. One is the naturalist, the second is the positivist. Here in intellectual property, first is the naturalist, second is the utilitarian or the economic value. The economic value is what that we are all familiar with in terms of what intellectual property is today. The moment we say intellectual property, you all will certainly immediately believe we are speaking only of the utilitarian economic side of this, which is true. But in terms of the copyright, particularly in terms of the French Renaissance, it is also the natural right. The author, the painter, the sculptor, or what you may will, has the essential inherent natural right to his product because of the ability, the God-given skills or ability inside. Not about an equation. It's not about an algorithm. It's not about using a data. It's about what is there inbuilt. That is a point of distinction with reference to the philosophy of copyrights. Let me move forward now. In terms of overview, I have to now quickly move forward a few decades. Now, after the United Nations established, and we have for intellectual property, the capital then, the organization was BIRPI, Burpee, and the capital then was Bern. But essentially, you might well agree with me that until the end of colonialism, for which the harbinger is Indian independence, which gave a tremendous boost for the independence in Africa and Latin America, and including in Asia further down to Indonesia and etc. There is a rush of new countries. We have in 1960 something called a declaration. This is called the Colonial Declaration of the United Nations, in which India played a critical role. History is certainly relevant, even for intellectual property. Because of that, there is, other than the European nations who were there earlier holding the intellectual property rights and membership in the intellectual property organization, today for the first time the rush of newly independent states and countries from Asia, Africa, and Latin America. As a consequence of this, the capital of intellectual property shifted from Bern to Geneva, where we have the European United Nations office in Palais des Nations in Geneva. Right in front of that is the Wipo building. This is called the World Intellectual Property Organization today, but there was none then. So after the Second World War, in 1967, the member states agreed to establish another convention. This is a convention to establish what is known as the World Intellectual Property Organization. This is an international treaty to establish the World Intellectual Property Organization to meet up and respond to the changed needs in the post-war period. Okay? Now this, with enough number of states having ratified or acceded to it, this convention came into force in 1970. So 1970 is the time the World Intellectual Property Organization, as we know today, is established. In 1974, by a decision of the United Nations General Assembly and its subsidiary organ called the ECOSOC, Economic Social Council, Wipo became a part of the United Nations system. Today, as you see, my friends, we started off after the post-war intellectual property not being a part of the United Nations system. Today, intellectual property is a part of the United Nations organizational system, and it has its own organization to deal with it, like WHO for health, ILO for labor, FAO for food and agriculture, ITU for telecommunications, etc. Wipo is the exclusive intellectual property specialized organization of the United Nations. You might ask me now, because you know more than I do, but why are you saying exclusive? What happened to World Trade Organization? That's a big deal. My friends, World Trade Organization, WTO, is not a part of the United Nations system. It is an international organization, but not a part of the UN. Okay, now that I have touched WTO, let me go to it. So we have the Wipo established. We have the Wipo established, and from 1974 as a UN organization, and we have now GATT is still there. GATT is still there only to deal with trade and tariffs, but there is no international trade organization as such. GATT is a small secretariat with its office in the UN building there. Now, what we were talking of was Cold War at that time. The Cold War ended by 1991. After the Second World War, from 1960 onwards, after the Korean War, we have the Cold War. And the Cold War ended from 1991 onwards. In 1991, the Soviet collapsed, the Soviet Union collapsed. There's so many independent East European states and so many Central Asian states that have become sovereign independent states. Now, this is when the Western nations have seen an opportunity with the end of communism, capitalism to become universal globally. Therefore, the next round of trade negotiations, next means next to the United Nations, World Organization, World Bank of kind of 1945 post-World War victorious powers. Next to that phase is a second phase after the Second World War, which started, and that is the Uruguay round of negotiations. Now, to cut the long debate short, Uruguay round of negotiations in the beginning did not have intellectual property as a part of trade. Till now, my friends, historically as we're looking, we are still on the same pedestal that intellectual property is not being a part of trade negotiations because intellectual property was not a part of GATT. GATT was the only small trade setup with dealing only with the tariffs. And now we have, for the first time, the Uruguay round, but in the Uruguay round too, it came up during Clinton's time in the United States. It didn't come, was not there. Then the pharmaceutical lobby of United States saw this as an opportunity to involve mainly from the pharmaceutical angle, but then you can't say only one. So the whole intellectual property, they pushed, the pharma of United States pushed, no hesitation in saying this, and you should know, pushed the item of intellectual property to be involved, to be taken up by the US government in the Uruguay round of trade negotiations so that intellectual property becomes an integral part of international trade. Meaning thereby, the comprehensive regime of international trade will apply to the specific aspect of intellectual property as well. This is a conceptual, historical, and in the history of intellectual property itself is a distinctive path. It's a different way. Now, the Clinton administration, the US Patent Trademark Office, including the then Commissioner Bruce Lehman, who's speaking of late 80s and early 90s, objected to this. They said, no, let's not get into that, and let's not lose our aim now is to make sure that capitalism spreads all over and there will be a global international trade. A global regime where trade could be maintained harmoniously with uniform standards between Europe and North America and among all states, among all countries, including the developing countries and the least developed countries, LDCs. All of them, irrespective of their economic status, background, per capita, GDP, income, they should all be governed by a single set of normative standards of international trade in terms of trade in commodities, in terms of tariff maintenance, in terms of all. That was the US agenda. But later, as it moved forward, the pharma gained further ground in the Senate and Congress, and they came back, and now the United States changed its policy. And for the first time, United States is the country and the government that at that point in time took up the integration of intellectual property into the Uruguay Round, and that resulted in the Dunkel Draft, and that resulted in what you know today as the TRIPS, Trade-Related Intellectual Property Agreement on Trade-Related Intellectual Property, which is an integral part of WTO, which came into existence in 1995. So 1945 to 1995, there is a sea change. There's a change of night and day, as it were. Now we have TRIPS, and TRIPS, what is TRIPS now? Let's quickly go. I'm trying to address 1 second to Mr. Anthony.
Yes, sir, please.
Please tell me the time. How much more do I have left?
It's okay, sir. The Gifty ma'am is also here inside the webinar room.
Okay.
So it's okay that we could understand that at the beginning we have lost some time. So it's okay, sir. It's up to you. You can take the exact 1 hour. No issues.
Okay, appreciate. Thank you very much. And let me go further. Now we have TRIPS. Friends, we have TRIPS now, which is a part of WTO. WTO, which is not a United Nations body, even today. WTO is an international World Trade Organization, but not a UN body. We have WIPO, World Intellectual Property Organization, whose mandate is exclusively intellectual property, while WTO's mandate is not intellectual property alone. IP is only one segment of its overall thing. And in fact, for WTO, IP does not matter. I mean, IP is not the big thing. The big thing today still continues to be the trade sanctions, the NAFTA agreement, whatever that's called, the American and South Pacific Australia agreement on trade. That's what that matters, mainly, or 80% or 90%. And TRIPS is only 10%. For World Intellectual Property Organization, WIPO, 100% is nothing but intellectual property. That is one. Number two, there are about 24, leave TRIPS alone, there are 24 international conventions, treaties, and agreements covering patents, trademarks, copyrights, industrial designs, etc. And all these 24 international conventions, treaties, and agreements are administered by WIPO. In Indian bureaucratic terminology, the nodal agency, the nodal department for the administration of international intellectual property as a whole and the international convention treaties happens to be WIPO. WIPO entered into an agreement, the WIPO Director General and the first Director General of WTO entered into an agreement in 1995, which is the relationship agreement between WIPO and WTO. Why is it so? Number one, the applicable law in terms of for the lawyers or law students or the law lecturers, the applicable law, or if you have a case before the Kerala High Court, or even whatever, even in the Sessions Court, the case will be decided by what is the applicable law, what are the sections you quote. That applicable law internationally is contained in these 24 treaties and conventions. All of them are administered by WIPO. The Paris Convention on Industrial Property, the Berne Convention on Copyrights, the Hague on Designs, the Madrid on trademarks, the entire regime, all of them are administered by WIPO, WIPO with its own institutional mechanisms. Now, so entire legislative system of all the member states, WIPO member states are 192 countries today. Okay. Now, all the legislation, the intellectual property legislation of all these countries is available on a portal on Wipo website, wipo.int, wipo.int. You go there and you will find all the information more. And these 24 conventions are broadly divided into 3 categories. One is the intellectual property protection system, that is one. Second category is called the Global Intellectual Property Treatise. The third is the classification. If any of you, some of you, I am sure, are patent examiners or scientists or so, in addition to the lawyers and the intellectual property law teachers that I'm sure that there and I know, is that you would know that if you have to today, if you invent today a treatment, medicine, or a method of personal protective equipment, PPE, for COVID, you invent one, you want to patent it either in India, I'm sure you want to patent it all over the world today because there is so much of market anyway. And you can make tons of money if you can do that. What would you do? Under what? There is something called a classification. And these classifications are related, there are treaties governing the classification system, and there are unions under that. And this classification, if it is patent, it relates to patents. It's copyright, it relates to copyright. If it's trademark, it relates to the trademark classes. So those classifications and subclasses are given in those classification treaties. Now, they come under the substantive law of intellectual property protection treaties system. These are the Paris-Berne kind of treaties that we mentioned, agreements. In between, there is something which Wipo owns up completely, and that is what Wipo is, in a way, Wipo lives on. These are the registration systems. Like patent registration, if somebody in Ernakulam today wants to file a patent for the PPE of COVID, or for a vaccine, or for a treatment method, medicinal treatment for COVID, what you want to do is, you know the process is, you can go to our patent office, the country of origin, which is India. You have so many patent offices now. Historically, there used to be only one in India, in Calcutta. Now there are more. Calcutta patent office, patent IP office was there from the British time. Now they are there everywhere. Now you go there and you put it under a certain class. Our patent examiners there will let you know. And you will go through the whole process of inventive, preliminary examination, post-examination, whatever, all that you do, get for a preliminary report or post-report, export report, etc. All that is possible. Then you want to file it in all over the world because there is market, or you want to file it in 30 countries, 40 countries where COVID has greatly affected. You know what? If you want to file in each country, you come to USPTO to Washington, Alexandria. You will have to engage a patent agent. You will have to pay the patent fees. You will have to have a patent council. You have to go through all that. You have to go to each European capital like that, or go through EPO, the European Patent Office, or go to JPO, Japanese Patent Office, or go all over the world. Meaning thereby that before your invention gets you a single cent or a rupee, in our terms, you have invented, you have perhaps invested, say, $250,000 to $1 million. Because wherever you file, other than your native language or native country, you have to translate it into that language. You may have to translate it to Spanish, French, Portuguese, whatever. English is our language though. The Dutch, wherever, it depends on that. So translation is an expensive phenomenon. In order to deal with these costs involved, for a multinational enterprise, it is okay. Even for a multinational enterprise, it is not economical. To deal with these cost things, Wipo came out with a treaty called Patent Cooperation Treaty. Under the Patent Cooperation Treaty, under the PCT system, it's like you can file in your country of origin, in India, in the nearest patent office, and designate 150 other countries as your filing countries. Okay? Your virtual filing countries are 150. That you can do under the PCT by filing. Number one way is to file in Indian Patent Office and give the PCT formula. Under the PCT, you involve 100 or 150 other countries. Or you can file straight under the PCT in Geneva, in the Wipo office, in the Patent Cooperation Treaty system, and there indicate as many countries as you want. Basically, you want to file patents in the countries where there is market for your invention. That is the fundamental economic principle. Patent is filed in a country where there is market for your invention. By that, you want to make sure that nobody else files a similar patent because you have already filed. And that you have already filed, in other terms, is called priority in patent law. You get the priority if you file first. And by filing in other countries at the same, in one single time, number one, you are getting priority in all other countries as well. But at the same time, the expenses are cut. So this is the most economic and this is the most universal method of, I'm only taking patent as the example. I could have taken trademarks under the Madrid registration system as well. So this is an example. These are the advantages. So this is the second registration treaty. These are the three tiers of the legal, practical, and mechanics of the system. Now, I want to rush early because I'm really worried about the time factor. Now, so we have seen that, now TRIPS quickly. Let me just go over TRIPS quickly. TRIPS provides, we have noted that it's an integral part of the trade. For the first time in history, intellectual property has become, only from 1995, a part of the trade. Otherwise, it was independent. No French author wrote something for trade. But today, a French author writes, that is protected by TRIPS, and it becomes a part of international trade. Nobody writes a novel. Like Jesudas did not sing songs because he wants that to be a part of international trade. But today, if somebody wants to copy it and put it in his own different picture, or the soundtrack, audiovisual is different, then there might be a case for the script writers and for the singers and for the whole Bollywood, Tollywood, whatever, all that goods, the film Hollywoods of India. Now, so TRIPS has provided essentially for the integration of intellectual property, though the substantive part of TRIPS, the substantive law, the substantive intellectual property law under TRIPS is even today essentially contained in those 24 treaties that are administered by Wipo. Mind you, friends, please remember this. Please remember this. The substantive international intellectual property law even today is governed by the law, by the conventions that are administered by Wipo. What TRIPS has covered is, TRIPS has become a bridge between the substantive international intellectual property law and the trade legal regime, the international trade regime. That is the bridge. Okay. Now, in this, there are two overarching points. One overarching point here is that being a part of the WTO system today, TRIPS matters are subject to the dispute settlement mechanisms of WTO. There is the dispute settlement tribunal, appellate tribunal mechanism in WTO, and that applies as much to trade and tariffs or commodities as much today to intellectual property. Number one. Number two, the bigger threat is that, and that is one reason why I would want to come to quickly the developing countries' apprehensions, is that if for violations of WTO agreement, which includes TRIPS as well, there could be sanctions under WTO, which could apply to TRIPS as well. Till now in history, the 125 years history from 1883 or late 19th century till 1995 or till WTO's existence, there have now been sanctions to intellectual property violations. But today, with the TRIPS, there are sanctions for violations of intellectual property. That is the reason why United States filed the famous mailboxes case before WTO. You know all that about the Article 7 and the flexibilities. TRIPS brings in flexibilities in the sense that the developing countries and the LDCs have respectively, after 1995, a period of 5 and 10 years to each one of them to implement TRIPS in their countries through appropriate methods or national legislation. And they thought the mailbox case before WTO by United States against India, at that point in time around 2000, was that India did not grant any mechanism under which the United States or other companies can file their patents with the priority rights which are granted under TRIPS. Particularly this, of course, goes to the famous process patents and product patents. Because India traditionally from the colonial time or before TRIPS recognized only the process patents, did not recognize product patents. I mean, the scientists who are, all of you would know what are the process and what are the products. Process is a process by which a product is arrived at, but India would grant earlier patenting rights only for a process, only for a particular process, but not to that product which may be arrived at through any number of processes. So that was considered a narrow mechanism, narrow method of Indian intellectual property, which was considered to be not in line with TRIPS. So anyway, the priority of mailboxes, and then eventually all that is amicably settled. Now we have, of course, the evergreening problem even today under Indian intellectual property law. So we have flexibilities in TRIPS, so that if 5 or 10 years more you can go. And TRIPS also provides for the Article 31 bond kind of mechanism, which is the compulsory licensing. Compulsory, which means, friends, please take a deep breather here for a second. Let me also sip a drop of water. The rights of the intellectual property rights, the IPRs in any of the categories that we have seen, from patents to trademarks through industrial designs to also other geographical indications, etc. is that there are also some exceptions. They are not absolute, not only in terms of duration, in terms of whatever, exclusivity and right of exhaustion, etc., but also because of, in terms of balancing with the public interest, there could be in certain cases where it is so necessary, or where the patent holder or the intellectual property holder is not using that, but only blocking the invention without any utility or use for the society. Under certain conditions, any country can either terminate that, take away those rights, or pass on those rights through its own state means to work it out. Now, there are 2-3 examples here. For instance, there is a medicine today somebody invents for COVID. Now, say in New York, today 85,000 people have died in the United States. 1.5 million cases are positive for COVID. Somebody has invented a vaccine or a treatment medicine or whatever that is required. But he invents, he takes the patent, he takes the global patent or a country patent and puts it in lock and key. He doesn't work. He doesn't work for 1 year, 2 years, 3 years, 4 years. What do you do with that? That's where in those circumstances, such circumstances, the state concerned, the government concerned can take over those rights from you and pass it on to a generic industry. Or even otherwise do that in terms of public emergency or national emergency declared by the New York governor, for instance, for New York. We need that. There is an invention. And distribute the medicines to all the inhabitants, to the patients, to the doctors, to the health workers who are on the front line of dealing with the COVID monstrosity. Now, this is called the compulsory licensing. I'm not going into the further details of it, but it's as a concept, I need to say this because I'm sure Dr. Woman would get into that. Now, quickly, let me say, I just want to turn and touch the base on the Indian system, and then I will stop. Now, with reference to India, basically, we have seen the legal history, the colonial history, and after that, we tried to change it several times after independence, and but then we have appointed a committee, a younger committee, for several years, and then it didn't perhaps really see the light of the day. Several times we tried to pass legislation, and it didn't work. Okay, and then so we have, after the TRIPS 1995, we have Mashelkar's committee. Mashelkar was the head of CSIR, Center for Scientific and Industrial Research, at the time, who had his own some 20 patents or 30 patents in chemical technology, a very well-known scientist. And eventually, we hear, and after mailbox cases in WTO, we have to comply with all the TRIPS arrangements. So from process patents, we moved to the product patents. Now, our Section 3D of the Patent Act, even today, is considered controversial internationally because we don't allow evergreening. We allow improvisation on invention if it is substantial, not like a capsule. If from a tablet it's made a capsule and patent for the capsule. No, India does not allow such a patenting. In fact, a similar legislation was there, something called Bayh-Dole Act in the United States as well before, of the Hatch-Waxman Act in United States. And then we have first, though in 2020, in 2000, I was at that time, like today, I'm giving the examples of COVID. I used to deal with HIV/AIDS. We had done with the same kind of debate that we have today. We had the same debate in 2000 in Wipo. I used to make presentations only on that. At that point in time, we had the same policy, India, CIPLA, while the market, the economics, Adam Smith's economics tells us that where there is demand, that's where the supply, the merchant supplies the thing. That's where you get your profit. Where there is no demand, there is no supply. You don't sell saris to men. What's the point? So, similarly, at that point in time, the medicine, a 3-medicine therapeutic cocktail for HIV/AIDS in United States, which was patented first in the Yale University, was available for $50,000 in 2000 per head per patient per annum. 75% of the global demographic population of patients with HIV/AIDS were located in sub-Saharan Africa, where the per capita income was perhaps $25 per annum. Here is a case, my friends, where there was medicine available, where patients are looking for that, but there's no purchase power, pure economics. They could not buy. That's when Nelson Mandela came to power. Apartheid in South Africa, apartheid ended, and he came to Bill Clinton and said, what do we do? He passed a national legislation in South African Parliament that was questioned by the Department of Commerce in WTO. There was a case against South Africa in WTO. So Mandela came to Clinton and said, Mr. President, thanks for your support to me. And apartheid ended in South Africa. I became the president. What for? My people are dying like flies on the streets. 70% or 75% of sub-Saharan Africans are the ones who have the HIV/AIDS pandemic virus. Medicines are available in the world, but we are poor. We are colonized for 200 years. We have no money. What do we do? The dilemma that we have today in TRIPS between the South and North, between the developed and the developing and the least developed countries also came up in big way, my friends, in 2000. Eventually, for the first time in the history of medicines, a double two-tier system was agreed upon thanks to Clinton's initiative, where he when Clinton invited pharma to his White House.
Please continue, sir. Sorry.
Thanks. So President Clinton convened a conference of the pharma. Pharma is the Pharmaceutical Manufacturing Industry Association in United States, which is the biggest. That's the reason why TRIPS came into existence. And said, look, he spoke about the same economics to the pharma and told them, if you don't sell your medicines there, then they don't go anywhere, because then it's like dead capital for you. You invested so much and there are buyers, but you don't sell. So what do we do? So as a result of that, a two-tier pricing system came. He said, you can sell for the regular price in New York, in Europe, or in Africa, give them less. because Dr. Muhammad from Dr. Hamid from Bombay runs a CIPLA, and he said he can provide for $1 a day. And the government of India is underwriting it. And the whole world is there with him. The entire civic society of the world, NGO community of the world is supporting. Médecins Sans Frontières, Doctors Without Borders are supporting CIPLA. So you guys won't have anything, and CIPLA will supply all the generic drugs for HIV/AIDS to Africa and to Brazil and to Latin America, and you guys can just sit home without doing anything. That is the same compulsory licensing which India wanted to do at that time, which Brazil did for HIV/AIDS in 2000, is what the compulsory licensing mechanism is in TRIPS, which is an exemption, which is an exception, which is for those conditions that I mentioned. And India used it within India only once, that is for giving the cancer drug to NATCO from Bayer. Now, my friend,
Sorry, sir. Please continue.
okay. Now I turn quickly. I want to come to an end. Now I quickly turn to the other assets of India, which are relevant in terms of intellectual property. I haven't spoken much about. That's called the geographical indications and traditional knowledge, because this is very relevant. Geographical indications, earlier we had something close to trademarks, something called appellations of origin, which was governed by a treaty. Appellations of origin is essentially to show that this product is from this particular, originated in this particular area. That's called appellation of origin. But now, as it moved forward, this is also a deal of the negotiations in the Uruguay Round. On one hand, the United States, motivated by its pharma, had gotten the entire TRIPS into trade. Then the Italians, the French, and the Europeans in general had taken up a point to negotiate with the United States before the United States could push its agenda further globally. They said, look, if you want TRIPS to be here, then I would want. Okay. Then,
Yes.
Then the Europeans, particularly the French and the Italians, the French said, if that is the case, if you want intellectual property for your medicines as a part of the global trade, I want my champagne, my Bordeaux, my wines, my spirits, without which the French cannot live, all of that to become intellectual property. Then the Italians said, oh, Paronto, let us also have, we would like to have the Italian cheese as intellectual property. So there cometh the question of geographical indications, meaning thereby that the wine with that particular flavor that comes from Bordeaux province, that comes from the champagne, that comes from the Champagne area, would have exclusive intellectual property rights. This is a geographical indication. If Americans ask, what is that geographical what is that intellectual property? That is intellectual property for the French. That's what we want. Oui, ça va. You agree? We agree. You don't agree? We don't agree. As a result, for the first time in the history, my friends, we have spirits and wines have become intellectual property rights. It has become as much an enforceable right under TRIPS as the patents and something like a space technology can become intellectual property. Geographical indication has become intellectual property. Now for India, what is our take for us? Our take for us is this. We have Darjeeling tea. Okay. Why is Darjeeling tea is famous not from today, from the British time? And so why can't Darjeeling tea become geographical indication? and be protected by us, by the TRIPS agreement. Also, there is so much of traditional knowledge among the native Indians in United States, among the Amazon tribes in Latin America, among the several African countries, and in India, elsewhere. What happens to that? That was not covered as such in TRIPS. Because in TRIPS, I can remember, because I was in the government at that time, in the central government, we were not excited at all about the Uruguay round of negotiations and TRIPS coming into existence. We were one of those because of who flexibilities were built into TRIPS. It's because of us. Despite us, product patents came, but it's because of us, the flexibilities, the compulsory licensing, or Article 7, Article 27, Article 31, all of them came into TRIPS. I mean, like, I seem to put my collar as if like I'm still in the government. That was long ago though. Anyway, so now we have noticed that there are several yoga positions, like about 3,000 yoga positions that had been patented or trademarked elsewhere in the world. And there were attempts to patent neem, a neem tree, which has that taste, bitter taste, leaves, etc. Then the Karelas. So much of traditional knowledge is being taken away from India and other countries by kind of biopiracy, by the industrialized nations, and invent something there, and then sell back to the owners, to the original owners. Now, for these things, like the turmeric that's being used for, for the wound healing, etc., in India, from India onwards to Thailand, etc. And then also, if like basmati rice is not grown in Kerala and in Andhra. Basmati rice is grown in Punjab, either side of the border, because it has its own geographical flavor, the length. Now, these are all, there have been attempts to patent this, basmati rice, neem in Europe, basmati in United States, turmeric in USPTO. There have been attempts and they were given. Then under Dr. Mashelkar's leadership, we contested all of them and won. Well, there is something called Texmati in Texas now. That's a different matter. But in neem case, neem in Europe, we won. Turmeric in USPTO, we won. Basmati before USPTO, United States Patent Trademark Office, India won. All this, how did we win? We won means we defeated. We got the governments and those patent offices resigned the granted patent to them in respect of those patented inventions, the so-called patented inventions, by proving through evidence that in India, Indians and in India certain communities have had the knowledge of the specific use and property of these elements from immemorial times. We quoted the Sanskrit shlokas, the Vedas, the Unani medicines, the Persian, the Urdu, all these items in evidence to show that in India we knew all this. Once it is known, there's no invention that you are doing. The use of it is known already. So this is no more invention. So resigned, annulled the patent that has already been granted. Now, for instance, this is done through this process. Then under the leadership of Mashelkar, Dr. V.K. Gupta, at that time, friend of mine, he had compiled a database to deal with these poaching, encroaching intellectual property entitlements from abroad. And that they built a database called Traditional Knowledge Digital Library, TKDL. TKDL is a defensive mechanism for India to disprove the patent entitlements in the foreign patent offices. And like similarly, the Jeevani, Arogya Pacha of Kerala, you all know more than I do, because I'm really worried at this point in time that I'm overstepping my time. I want to quickly conclude now that we have the issue now. Finally, I want to close it here with this thing. What is it for us to take in India from intellectual property? What is it I want to share with you? Number one, apart from all this, the international intellectual property and the intellectual property overview is that innovation is essential for technology, and technology and capital are two legs for development in the modern era. We have every year thousands and thousands of masters in science, engineering, and technology coming out of different universities and colleges. We have several doctorates coming out. So many, even since independence in the last over 70 years, so many. But I'm trying to talk to each of you personally. And that is the purpose of my, if I have a mission, as it were, I'm sorry to say that, if I have a mission through this lecture, my mission is to reach out to each one of you and say, fill in these blanks. How come India is a developing country? How come Silicon Valley in California cannot exist without Indian computer scientists? But how come in India, we are only the backroom boys in Bangalore or Pune or Hyderabad or elsewhere? But how come we are not the Silicon Valley? How come we are not the Apple? How come we are not the Microsoft? How come we are not the Google? But how come we are all there in all of them, including leading them? That's where the intellectual property comes into picture. And that's where our scientists, our technologists, chemists, pharmacists, the core army of science, technology, and innovation have to take up invention, bring up technology. Capital will follow. I'm very much interested in the foreign direct investment because I was involved in that in the first initial stages of bringing foreign investment into India through legal mechanisms. But in addition to it, as I am addressing you as technologists and lawyers, please, all this purpose of mine is for you to motivate you to become the inventors, to become the technology harbingers, and to see that the government encourages you and the private capital from Reliance or whatever, so many billionaires in India, comes to scaling up and commercializing these inventions there should be a private-public partnership between the universities, the industry, not for donations, for bringing out the technological innovations to the market and to export it and to make export earnings back to India. So technology and capital, and technology is the backbone of intellectual property. Today, even in copyrights, because databases are copyright, or for patents, or for trademarks. I want big intellectual property trademarks, big intellectual property patents, big intellectual property, whatever, industrial designs for India. And that's when we have to move from generic industry to pharmaceutical manufacturing industry. We have to move from village agriculture to composite global agricultural markets. So I think we have a bright future. We have an army of brilliant minds that is globally recognized. And we become the first famous case in United States in the patents in the modern times is something called Diamond versus Chakrabarti, where this Chakrabarti from India comes here and discovers a fungus, mixes it, and puts it in the water, which isolates the oil leak and separates the water. That is Diamond versus Chakrabarti, the United States Federal Circuit case and Supreme Court decision, by which a maxim came that anything under the sun that is made by man can be patented. Anything under the sun that is made by man can be patented. That itself is heralded by an Indian, which is the modern harbinger of United States patent law. So therefore, India has to do that. And all of you, if you are scientists, etc., please do this, take up on your shoulders and move forward and let India become the intellectual property capital, investing, inventing country. Thank you, Mr. Anthony.
Thank you very much, sir. So we have a couple of questions in the chat box. Can I read it out, sir? If you do have the time.
Yes, go ahead.
Thank you very much, sir. Sri Lakshmi Kamaya, she had asked, we are making computer programs and why we don't have patents for the programs we make. Is Copyright Act overpowering IPR in computer programming? That's what she asked, sir.
Okay, let me quickly say that. Well, the whole of the third and the fourth industrial revolution, which is from the computers to the current AIs, everything is patented and copyrighted too. So whether an abstract algorithm, which is the undercurrent of a program, whether it could be patented is a question. But when it is transformed and put to use on a hardware, it could be patented, yes, possibly. It's like a business method that could be patented. Okay. Next.
I'm sorry, sir. I could find only one, and there are a lot of thank you messages that's coming up. Can you explain the IPR rights in agricultural products, mainly pesticides?
Okay.
Yeah.
Yes. The agriculture has two aspects to this. One is there's another convention called UPOV, Union for Plant Varieties Convention, through which one is like, for instance, a seed. If is capable of, when you plant and in the field, and if it is capable of, say, yield of, say, 1%, then you genetically modify the seed through a certain method, you can patent it. Then that becomes a modified, genetically modified seed. Of course, we have a big debate in India about Monsanto, but this comes under the one variety is the Wipo convention, a separate convention, which is a part of the Wipo. It is a Wipo sister organization. There is a separate convention. There is a separate body to it. The Union of Plant Varieties, Wipo, that is for that. But so intellectual property right with reference to genetically modified could be a patent. And if it is a particular product coming out of it, like there could also be GIs, I mean geographical indications, like the wines and spirits of France. We could say some mangoes of UP, or there is one brand in Andhra called Banganapalli, whatever that's called. So something like that. Or in Kerala, there might be something. So that could be a geographical indication, which is intellectual property. Now, so pesticides are concerned, they could be patented if they don't touch on, because they touch on hitting only the pests, not the normal plant life. If they impact on the plant life, they are not patentable under TRIPS or under the Paris Convention. If they are going to hit, the siding is pesticides, then it could be patented. You could have to show, of course, you have to go through the inventive step, the novelty, the prior art, whatever, all that, the utility, all of those things have to be shown. Then it could be patented. Okay. Yes, please.
So the next question, whether the IPR is relevant to the SMEs in the pharmaceutical sector.
Yes, small and medium enterprises, of course, do not have the same investment as the MNCs or MNEs, multinational enterprises. But certainly, intellectual property rights can be there to support them. It depends, like to the extent it's what intellectual property right. Are you speaking of, if we are speaking of patents? Yes, it could be. It depends upon what you, I've been seeing, for instance, recently, in so many WhatsApp messages, so many personal equipment, PPEs, COVID, people going, why not? It could be patented. Well, it could be, some of them could be utility models. They may not be large-scale inventive innovations, but it could be utility models, but that could be patented. Why not? It's possible to make them, yes. So SMEs have an opportunity, and we have in Wipo, I'm no longer working for Wipo, I'm retired, but in the World Intellectual Property Organization, there is a sector, there is a section that deals with the small and medium enterprises. So SMEs have a significant role in the intellectual property field, and IPRs can enable them and help them. And also, under what we call the Wipo development agenda, Wipo has a development agenda like VN today has a sustainable development agenda. Once upon a time, we used to have a Millennium Development Agenda, MDGs, a Millennium Development Goals. Similarly, Wipo has a Wipo development agenda, under which it is meant essentially to help the developing countries and the least developing countries, to help them in intellectual property innovation, technology, mobilization, and gaining expertise. And SMEs could be a part of that scheme to help them. Wipo has, I'm sorry if I say we, because I can't officially represent Wipo, I'm not, has something called TISCs, which is which could be for, this is the support for technology for the developing countries, TISCs. We could have under the TISCs to support SMEs, particularly in the developing countries and the least developed countries, LDCs. Next.
So the next question is, TKDL is a good choice, but sir, if we documented all the knowledge, it will lead to another kind of colonialism. So what is your opinion on that? And there is one more question that I'm adding to it, whether IPR is right.
IPR is right or left or right or wrong?
Right or wrong, sir, I believe.
Okay.
Yeah.
First, well, these two are related, but first, on the TKDLs. Now, it is true that we have, for the last nearly from 2000, now it's 20 years, I've been personally involved with that. In Wipo, there is something called Intergovernmental Committee on Traditional Knowledge, Genetic Resources, and now Traditional Cultural Expressions, earlier called folklore. This committee was established on the basis of a fact-finding survey done for about 2 years in Asia, Africa, and Latin America, and some developed countries as well. And on the basis of it, they came to this, that biopiracy is a bigger problem. Like, for instance, you might know, now that we're talking about, let me say, there is something called rosy periwinkle in Madagascar. Rosy periwinkle is a plant with, not like our cactus, but it's a plant. I'll come to a cactus example also, with a flower. The local people of Madagascar had used that for some growths on the body, put it on, or if there is wound and then it had grown up, and then you put that inside and that grows up. And eventually, that was patented and used for ovarian cancer. And that comes from the rosy periwinkle of Madagascar. Now we have Hudai cactus in Kalahari Desert in East Africa. Uganda, Tanzania, Kenya, Namibia, etc. Where these San tribe people, they would walk around, for they are nomads, they walk, and there's nothing in the desert to eat. So what they do is that they take this cactus thing and then the leaf, and then keep on munching on that. And they go for days, weeks, per month, nothing happens, and they live. Now, that was written by an anthropologist, a social anthropologist from England, about that, the herb or whatever that's called, the cactus. Later, somebody patented it, and they sold it to Pfizer here in the United States to use that as a medicinal property for obesity in the United States. Similarly, there's something in, say, in Pacific, in Marshall Islands, where they used to drink a certain portion, like when there is joy or sorrow, they drink up, and then they dance and stuff like that, drinking that. And that brings them calmness, and that's used. And the biggest medicine for depression is made out of that. Now, this is $1 billion industry. So biopiracy had been going on. Mind you, the word they use is biopiracy. had been going on. Now, they had no help. Now, what India had done is to stop that. To stop that, there are two ways of doing the traditional knowledge being used in two ways. One is a defensive approach, the another is a positive approach. Positive approach is the Indian scientists patenting themselves and making it a global industry. Why can't the Indian scientists bring from these plants, and if foreigners can patent, we can do it? Why don't we do it? We didn't do it. So what we want to do now is stop the foreigners from converting this into medicine and making bucks out of that. And we are losing. Our traditional knowledge is being lost. So therefore, what we are doing in India has been use the TKDL. It is true that it is risky, but it is true that is a defensive mechanism, because TKDL is today linked to the USPTO, United States Patent Office. If United States Patent Office today has to grant a patent to something, they will have to first show. We are asking in Wipo, India has asked and African countries have asked that if you are doing a biotechnology patent, show there should be an item in the patent application. There should be follow me. There should be a question in the patent application which says, has it been derived from any natural source? Show the source of origin. We want that to be included. That's what India had raised. If that is the case, then immediately we would know whether it's our traditional knowledge or not. And we have linked up our database to the patent databases of Wipo and the patent databases of other countries, the leading patent organizations, USPTO, EPO, JPO. So therefore,
this will be a hit to Indian economy.
Hello, sir. Hello. Ram Rao, sir. Could you please unmute yourself, please, sir? So yours is muted. Can you please unmute, sir?
Sorry,
Yeah.
I'm sorry. I hope I have not lost much on that.
No, sir. No, sir. The last sentence, only the last sentence.
So therefore, we have used TKDL so that we are not letting our secrets to be taken. This is the question and the answer. To the question is, we are not letting any secrets to be taken by others. We are taking more measures to show that they have to show the source of origin, because the patentee, the patent applicant will have to show how he got this and where he got it, where this microbioorganism is available. That is the source of that. And once that is there, then we have our TKDL, and in which case, USPTO will have to say it can't be granted because it is the traditional knowledge. It is well known. Once it is known, it can't be granted. So that stops. Instead, TKDL, in my view, is a very positive instrument. It doesn't promote any secrecy being stolen by others, but in fact prevents others being patented on our traditional knowledge. Thanks. Next.
We have another 8 more questions. My dear participants, I think I should not take any more questions after this. I'm really sorry for that. I don't want to disturb Dr. Ram Rao sir a lot and put him in difficult situation, because I had asked only 1 hour and he have extended 2.5 hours for us. So moving to the next question, can we patent our research material like research papers and articles and theses? Clubbing with another question, sir, I have created a chart in my article. How can I apply IPR to this? So 2 questions basically. Can we patent our research material like research papers, articles and theses? And another one, sir, I have created a chart in my article. How can I apply IPR to this?
Well, the chart could be copyrighted. You see, that is one. And then the research articles and materials are ipso facto. By themselves, they are copyright things, because you don't have to, like patent and trademark, for copyright, you don't have to necessarily apply for a grant from the government. Not grant from the government. Patent is a right that is granted by a government. Patent is not granted by Wipo, patent is granted by each country. Same trademark. But copyright is there inherently for anybody who writes something, who sings something, who plays a drum. But particularly for articles, you don't have to, it is intellectual property. You don't have to, the research articles, the chart, all of them, they are intellectual property of you, whether you register them as copyright or you don't register them. Because under the natural law doctrine of copyright, that becomes inherently your own authorship. You don't have to necessarily be registering it. But you can register it as copyright because a chart by itself is not a patent material. Okay? In order to do, whether through your scientific research articles and through scientific charts, if you invent something and to support that invention, to describe that invention, if it's engineering in terms of graphs, in terms of whatever that is used, an engineering patent would have those supportive diagrams. If it is a chemical composition, if it's a pharmaceutical composition, you have those equations and the lab results. So those results are the descriptive material which have to go, and those diagrams are the descriptive material that have to go along with your application for the patent. But it's a research article as such, you have a copyright inherently, which is also an intellectual property right. Copyright is also an intellectual property right, for which you don't need to register the copyright. It is there. Copyright registration is necessary if you are producing a Bollywood movie, and if somebody is going to steal your tape and is going to, pirate that or show the movie here in New York before it is shown in Bombay or in Ernakulam or Cochin, then you would want to take some measures. So, but if it's this, so research article as such, you can't patent. You can't patent a research article. What comes out, my friends, what we are patenting or intellectual property is that brain wave, that creation of that mind, that invisible, intangible process of mind, which might result in a machine, or it might result in a product through a machine. All that is patent. Here you can't patent them, but you get intellectual property other than patent. That is mainly through copyright. Okay.
Moving to the next question, sir. Even though many countries did not accept the sui generis system of IPR, how our nation adopted this system?
I didn't get it again.
Sir, repeating. Even though many countries did not accept sui generis system of IPR, how our nation adopted this system?
Sui generis means essentially it is a special thing with reference to what the special circumstances would, or your law or your system would warrant. That is called a sui generis. Sui generis, we, for instance, for the geographical indications in India, we can use the sui generis method because that is the way we go about in terms of Darjeeling tea or in terms of basmati for that matter. Basmati was a big thing in terms of GI register expansion under TRIPS negotiations originally. So sui generis is like something which is not in contravention of TRIPS, but which should be unique to your own, which is more convenient and unique to your own system. So there is nothing wrong. Sui generis is not like a particular formula which country A did not accept, so India cannot accept. There is no sui generis. Sui generis means it is with the specific reference. That country may adopt one method, we may adopt a particular method. That is called sui generis. So if somebody doesn't accept sui generis and we accept, that has no contradiction to each other. Thanks.
So the next question is, apart from the options in physical sciences and manufacturing products, what are the opportunities available in social science?
Opportunities available in social science for what? For what purpose? This is my question to the questionnaire, to the one who asked that question. What possibilities that you want in social science?
If the person is there, you can unmute and clarify that question. For obtaining patents, sir. For obtaining.
Okay, no. Have it. Social science. What do political science, sociology, history, whatever. Well, all that is relevant, but that is not patent. I mean, like, if somebody gets Nobel laureate in literature this year, that is not an invention. That's not a patent. But he might have done so many books. He has written so many books, and he gets a Nobel laureate, and all those books are copyrighted by him. He has authorship rights. In India, his life plus 60 years. Under TRIPS and Wipo Bonn Convention, his life or his or her life plus 50 years, because TRIPS provides only the minimum standards, not the maximum standards, because the states can always, the countries can always have more than what that is provided in TRIPS. You can have more longer duration, you can have stricter standards, etc. But so I'm taking the example of literature. You can have Nobel Peace Prize, but then that's not patent. You know, patent is different. Patent is a specific thing that's only for 20 years now under TRIPS. In India earlier it was only for 14 years during the British days and later as well. So what we do in patents, we have seen the inventive step, etc. It is true, like you can have a new sociological theory, but that would not become patentable because it has no mechanical interpretation to it. But copyright, yes. You can trademark as well your name, perhaps. I don't know. But an industrial design, a book on Aristotle to become an industrial design, yeah, you can perhaps make a design and put Aristotle and its the name Aristotle on it, but otherwise it won't become an industrial design. Is it a geographical indication? No way, it's not. So I think, yeah, that's what I would say. I would like, you never know.
Next question, sir. The next question, Mr. Subbu, sir had already answered your question regarding can any computer program be patented. It's already been answered. But for the first part, I would also like to have his view, sir. I mean, your view, sir. Can a newly invented crypto system be patented in India? Can it be patented in all over the world through one patent application? Apart from the computer program, I'm not thinking from the computer programming concept. Apart from the computer program concept, can a newly invented crypto system be patented in India? And can it be patented in all over the world through one patent application? Over to you, sir.
The last one first. There is no single unitary patent in the world. There is no authority for any organization, any country, any institution in the world to grant one patent for the whole world. Patent is essentially granted by each country. What World Intellectual Property Organization does is to facilitate to take up your application filed in one country and circulate it to all the 192 countries in the world, if you so wish, for their consideration and grant by each country in its own discretion under its law a patent on the basis of the application that you filed. Otherwise, there's no single patent. Now, what you said, crypto. What is it, Dr. Anthony?
Cryptocurrency concept, sir.
Yeah, cryptocurrency concept could be patentable. Could be patentable right now. And in fact, you can check. Wipo has something called the patent scope. I will also add one more thing. Patent scope is the depository of all the international patents that go through Wipo, in which you can click on this item. You can go to that patent scope in wipo.int, click on that and see it's patentable. Where there are patents given, how many are given. Yes, it is patentable. It depends, but it is again for each country to grant the patent. Yeah. Next, any?
Last question. How IPR affects on quality of research?
I think, in my view, very positively. Intellectual property contributes to further research. Research contributes to intellectual property, and intellectual property contributes to further research. Whether because it gives a feeling of satisfaction to your mental skills, knowledge, and assets, a recognition, a value, and thus a right. To that extent, intellectual property does not in any case and should not, ought not debunk further curiosity for research. This, I think, is the overwhelming view that I will hold, though I do recognize that on the other hand, some might think that, people abandon research for only the property rights. No, people don't abandon. Intellectual property rights, if we are essentially thinking of any large-scale patents that are being taken over from the inventor by a company or a multinational enterprise. For that multinational enterprise, their only motive is profits, not research. But for the original inventor, it is the invention. And that gives further impetus. And even if the MNE had patented, but that still gives rise to further research because we know the patent material available. And based on the prior art, based on the existing body of research, the researchers in the field, in that particular field, will go one step further later because we already have a knowledge bank with us to move forward. So I think it is a win-win game. It's not a zero-sum game. Yep.
So that was the last question, and I take this opportunity to thank our beloved speaker for the day, the session 1 and the talk 1, Dr. S. Ramarao sir, who have immense knowledge and wonderful experience in this field, and he is the master in this field. And I believe that all the participants had enjoyed and it was a wonderful, fruitful session for you all. That's what I believe. And on behalf of St. Albert's College, the Albertian Center for Human Resource Development and Research, and on behalf of each and every participants who joined for this international seminar, I extend our sincere gratitude towards Dr. S. Ram Rao, the resource person for today. Thank you very much, sir, for your time. And you had spent a lot of time with us. You had promised the 1 hour with us, but you started by 8:45 and now it is 11:03. And I know that it's now midnight over there, in spite of your age. But I mean, I believe that it's about the commitment towards the innovation as well as the intellectual property capital. That's what I believe. So thank you very much, sir, once again on behalf of everyone. Thank you very much, sir.
Thank you, Dr. Anthony. I think it's now this is time for me to move to Kerala. But Dr. Gifty Woman said no, because I said if I can spend this much of time, why should I be talking at 1:30 in the middle of the night here? It is so early in the morning. I could have as well come to Ernakulam. And thank you all the participants for your patient hearing and sitting through this. And it's a great opportunity for me. And thank the host, Dr. Shane Anthony, for all that. Thank you. But if you want to contact me, please get my coordinates. Any of you who participated in this can contact me through Dr. Shane Anthony. And thank you, Dr. Anthony.
Once again, thank you very much, sir.
Thanks. Have a good day.
Good night, sir. And we had we have the second speaker for today, Dr. Oman, Dr. Gifty Thomas Oman with us. But I believe that we will move that session towards the second part of today. So because we have already passed 11. So we will rejoin at 2:30 and we'll reschedule those three sessions between 2:30 and 4:30. Request everyone to rejoin the session at 2:30. Thank you very much. Have a good day. We'll see at 2:30 p.m. Dear participants, you can use the same link to join for the webinar. I am not closing the webinar room. Instead, I will stop the live as well as the recording, and we will come back maybe by 2:15 or so. I will be available in my desk by 2:15. In case if someone asks for the permission, I will be there to permit them inside the webinar room. So we can see by 2:15, and the session will start at 2:30. Thank you very much.